Good morning. We're back in Massachusetts for the verdict watch of Karen Reed on trial for the murder of John O'Keefe. Now, this is the third day of deliberations with the jury, and they enter it at 9 hours under their belt. Reporting on X and elsewhere has the jury rather dressed up today when they arrived. Yesterday, they were all in sweats and casual attire, like it was going to be a day. Today, they look even a little more spiffy, according to some, even more so than when they showed up for trial every day. Is that a sign? Who knows? But what I do know is they do have a question, and they'll be coming into court. So I will be ready to get that for you. So we wait until they arrive.
Court is in session. Excuse me. I was just informed that somebody O'Keefe just informed.
So, Counsel, why don't you come on up?
Okay. It's been said that they had a question. I hope that we actually get to hear the question. Those of you that followed the live trial with me will find this rather humorous that the first thing they did was a sidebar. I do find it, but it is a very serious courtroom. I will say that Karen Reed and Alan Jackson this morning did not look very cheerful. Everyone is quite serious and somber. And I do not see the O'Keefes for the jury question. I think that they will wait for the verdict call. I can't imagine them running back and forth for questions or sitting here all day. I do understand why the Reeds are here. Karen needs to be here, back and forth, and I'm sure they're all close by. This morning, when the judge asked the questions of the jury and got them to deliberations, or once they left to start deliberating, she did advise all the attorneys to be back without notification at 4 o'clock in case the jury wanted to go home. She didn't want to have to send a notice to them to come in if the jury wanted to leave and wait on them. She told everybody to be back by 4, which they all agreed. And that was all for this morning. It was quiet. Now, let's say we are exactly 11 hours and 5 minutes plus into deliberations for this jury. Started on Friday. They did an hour or so. Then yesterday, they had the regular day, sworn in the morning. The defense brought in a motion to change the verdict slip. Apparently, from what I saw, really all they wanted was to divide up charge number 2 to have a not guilty on every single one of them instead of a not guilty of any for manslaughter. Manslaughter has many subsets, so it does look a little different because you don't just say guilty. You have to say guilty to which subset or which subsets could be more. But there doesn't really need to be a not guilty on each one.
Bob, I can't do this. I can't.
There was a hot mic there for a second between Alan Jackson and Robert Alessi, but we shall see. Quite the conversation going on. I'd like to hear the question on record and the answer. And we shall see. There's a bit of muffling. I think I had backgrounded out. Should be better now. I'm going to get this up right away for everyone. I do believe that noise could be the fan. I'm not sure. It is quite interesting to watch them talk about all of it. Oh, I do see Peggy O'Keefe coming in for the jury question. I guess we'll see what's going on. It does seem to be more than something simple. Although, all
Counsel, what
questions-
I'd like to do is I'm just going to read the questions to you now. So please take your seats.
more than one.
So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when you
It most certainly
when
was Karen Reed.
I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's,
All right.
why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
Okay, so it sounds like they're questioning if they mark her for the OUI, meaning that she was drunk over the limit. I believe the verdict slip says. Let me pull that up and read it exactly. Because, okay, for number 5, it means guilty of a lesser included offense, manslaughter, or guilty of a lesser operating under the influence of liquor, and check either that apply operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. That is from charge 2, number 5 on the verdict slip. So it looks like they just want to know the timing of that, whether that means she was operating the vehicle at the evening or in the morning, because apparently she was actually drunk at both times, according to the testing that was done. Now, we don't know if she kept drinking, whatever, but when they estimate the times, they can say that she was at the time of the incident that the Commonwealth is claiming that she would have had an over the legal limit at that time, because she also was pretty well still inebriated when she got to the hospital, which was many hours later. And so they're wondering, when she was driving at 5 o'clock, if she was also considered over the legal limit. But they would have to go over that testimony. That testimony, whether that question was asked or not, and whether they took good notes on it. They may be able to ask for the transcript of that particular testimony. I'm not sure. Let me just Google that really quick. Let's see. Can a jury in Massachusetts ask for a particular witness testimony to answer a question? Let's see. Oi. The jurors can ask for a particular witness testimony to be read back or played back to them. But there are some important conditions. The jury has to send a note to the judge. The juries have questions about whether a witness said during it, and they can request the specific portions of the testimony can be read back. It is at the judge's discretion. The court reporter would read the testimony if the judge allows the readback. The court reporter will return to the courtroom and read back or play back the specific sections of testimony that were done in front of the jury. In other words, the court clerk has to go to the deliberation room and read it. The judge would usually consult with the attorneys involved before deciding whether to allow the readback. So if they really want to know if she was drunk at 5 o'clock, if it was addressed, they have to ask for that specific witness's testimony. In that particular questions if asked, but they have to remember whether or not in cross-examination or in direct examination, the time of 5 o'clock was actually mentioned in the morning. And I can't for the life of me recall that it was, but I'm not on the jury. Hopefully they took better notes. I do know that they discussed the time of the incident and what her calculated blood alcohol would be at that time when she was driving. But not so much when she left John's house at 5-something in the morning. It's an interesting question. The other questions are interesting also. So either way, they have thoroughly read the manslaughter options, and they have definitely considered her statements and how much weight they need to give them. So we'll see. I'm sure right now some people are very hopeful, including the defense team, that all she will get is going to be driving while drunk. But we'll see. I mean, what does it mean? It's going to be a few minutes before they come back. We wait patiently. For the record, the humane jury instruction, is in regards to the judge found that her statements were voluntary, so they were entered into evidence. But the humane jury instruction lets the jury know that they can decide still whether they were truly voluntary and should give it the weight or not that they want. That they still have that option. Whether, to consider its voluntariness, they can disregard it if they find it wasn't voluntary, free, and rational. I think personally, when you decide to do interviews and you go out and decide to publicly speak, that does make them free and voluntary. Well, did you know they were incriminating? And if you were aware of that, would they really be deemed rational? Well, I would say she was a free, rational mind, but they were rather incriminating. So we'll see, what the jury might think about that, but it will be up to them. They can actually disregard them. We shall see. We don't even know if that instruction will be given, but it seems that Judge Cannone is really thinking it should be at this time. And in fairness, I think it should. She is very good at balancing both sides. And I think it will be read, whether it's objected to by either side or not.
Please be seated. Court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember if we can pull that up.
There's no time?
I don't expect that there's any time.
All right. So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips of Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes, you should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws and keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
right. So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
If the, I don't have a principled objection to it if the court adds the word if any,
I understand.
because every single, I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right. I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the guilty. So go ahead. I'll hear you further.
going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent. If you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the
We
parenthetical says
fixed it.
check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explained it.
All right. What
I
I,
don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be used. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense, it would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank you.
right, I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can. And we'll make copies, so we'll bring them here as well. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
All
all.
rise.
Well, there you go. We're going to actually hear the answers to the questions given right to the jury. So, okay. Now we wait for them to come back again.
Do you have those? So Tony will take those. All right, so
Okay, we're bringing the jury
thank
over.
you. Tori, how many did you make?
I am curious if this is a sign that we will get a verdict today and once these questions are answered.
All rise for the court, please. Jury's entering.
And the jury's coming in.
Court is back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together. And I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with the blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors is set,
Sure, why don't you come on over?
Of course, there's a sidebar. Of course, there is. They agreed to the instructions. She read the instructions, and now they're going to have something to say. It's so ridiculous. This has to be so hard on the O'Keefe family, the back and forth. I would imagine even the Reed family is very tense today. I'm sure that Peggy O'Keefe just wants this to be over. Well, she wants
I
justice.
heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All rise to the court, please. Jurors, follow me.
There we have it. we'll just wait to see if the court has anything else to say. But they have instructed if there are no further notifications for all the attorneys to return at 4 o'clock. That was the morning instruction. We'll see if she has it the same. Well, jury still has 3 hours and 15 minutes to deliberate before
Jury's
4
exit the court,
o'clock.
please be seated.
Are you satisfied, Mr. Yannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
Foot, all right.
Okay,
questions
we're going to
and
stay.
thoughts and
We're going to stay.
why was this objected to? And so we've been able to do it while we both tried to be
Okay.
jurors and
I don't know why she's doing that, but she'll be back in 5 minutes. So will we. I will make one note from the socials of those in the courtroom. When the jury entered, they were their heads down, eyes to the ground. They didn't look in either direction, not to the O'Keefes, not to the Reeds, not to the prosecution table, not to the defense table. They kept their eyes down. They are definitely working on something. I do believe we will get a verdict today. They are definitely chewing out something amongst themselves. Hopefully, it will be today. Okay, the judge has asked for a sidebar with the with the lawyers. And we can't hear, so I don't know. She said I'll be back in 5 minutes, and now she wants a sidebar, and we're not gonna know, but we'll see. I'm so curious. This is one of those trials where I'm debating on whether I want to get a hold of all those sidebars. Transcriptions can be expensive, but darn, just to know what was said back and forth and who said what, especially after some of them were disclosed, especially the one in February that the judge disclosed herself. Seems like some of them get pretty heated. My curiosity may be at the best of me. I don't know if full transcripts can be released if it's in appeal, though. I had to find that out. For such a tiny courtroom, it's very quiet, is it not? Like, that's quite an involved sidebar, huh? I think they may be talking about the fact that the jury seemed to be wanting just to tie up some loose ends. I bet you she's talking about not leaving the area, and it might be best for them to stay pretty close. I'm not sure what happens after the reading of the verdict. I don't understand if she would be remanded immediately if there's any guilty charge, or if she waits until sentencing to come back. And I don't know what happens in Massachusetts. I don't know why I don't know that. I should have researched it by now. But we'll find out shortly, because I don't know the tension today. The fact that the jury wouldn't look at anyone, I think they're pretty much decided on what they're going to do. The fact that they didn't look at anyone means they either did not want to disappoint Miss O'Keefe, or they are feeling that they don't want to disappoint Karen Reed, the defense or the prosecution. I don't know. Best to just look down, not look at anyone. I'm wondering if now that they know the statements she made on those interviews are evidence, if that's going to change anything. Some of those statements were in conjunction to how much she did drink. And she did admit on those statements that she should not have been driving. We're back.
You do Friday?
All right, so we'll see everybody at 1:30.
Okay, I don't know what that's about. See everybody at 1:30. I guess we'll find out. For now, I will just hold off. Okay, we have a sidebar. As soon as they get back from lunch, they just all walked up. As soon as they came back in, we'll see what they say. I do think that maybe we've got a nod that they should stay in the area because there may be a verdict. I don't know. Or they're talking about something else. It was quick.
Jim, can I have that question, please? Thank you.
Oh, another
All right,
question.
so as council knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not the position for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah. I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
Your Honor, I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever
do you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Yannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute.
Thank you.
Huh. She's calling them out for being late coming back from lunch. That's not the important part here. The important part is to get an answer to the jury that they can understand and that it's fair to both sides. Legally, she can't tell them what to do. Unfortunately, the jury's going to have to get her more information to go by. But the defense has a point. This could lead to the same situation that caused the mistrial in trial 1. If they decide that they can't decide on the third charge, she is going to send him back for deliberation, and we will not have a verdict today. She will not accept them after this short period of time. She will try to get them to decide one way or the other on the third charge. The last thing they want is another hung jury.
A very slight tweak with the court's language. I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns, and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Well, I just don't want to see another hung jury.
I won't allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I think
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't
Is
tell
that-
you to ignore anything, Your Honor.
all right, we are all set. So let's send this in, please.
All right.
Okay, well, they're going back again. We wait again. Okay, it appears they are coming back. It's end of day, just before 4 o'clock. I do believe this will be just to dismiss the jury for the day. We shall see.
Surrendering. Court is back in session. You may be seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. Jurors following.
Well, there we have it. No verdict for today, everyone. Well, we had questions. Karen Reed does look pleased, so she's looking that maybe there'll be a full acquittal.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is
Okay,
adjourned.
tomorrow is another day. Okay, so tomorrow is another day. See everybody back then. Good night. No verdict for today.